Seeks will maintain the privacy. I wonder what they cite here to approve the protective order. Oh, they do say in here, though, the court mentions this. The law's basic presumption is that the public is entitled to every person's evidence. That's your starting point, is that when there's a filing in court, the presumptive starting point is that everything is public. That's how our court system works. That's where you start from. And then you have to make affirmative arguments for why something ought to be sealed or protected. However, Federal Rules of Civil Procedure 26C provides that a court, for good cause shown, may make any order which justice requires to protect a person, a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Rule 26C articulates a single standard for ruling on a protective order motion, that of good cause. Federal courts have superimposed a somewhat more demanding balance of interests approach to the rule. P&G's interests relate to its trial preparation and defense. Those are important interests, and great care must be taken to avoid their unnecessary infringement. Social science research studies on their own occasion. Courts have taken notice. Here, ruling on admissibility. However, it will be the response of the courts in which the state's trial the record and argument for this court shall the district court act within its discretion in holding that the senator's interest in keeping senators outweigh the two. Okay. First, the senator's purpose is the protection of the public's health. Central to this purpose is the ability to conduct probing scientific and social research supported by a population willing to submit to in-depth questioning. Okay, so they did uphold this protective order here, which makes sense. But it's funny that they would cite that case. Courts routinely fashion protective orders for purposes of shielding sensitive information about third-party witnesses, if so requested by a party, to the action. See, for example, Fansworth and Procter and Gamble. That's a crazy. If you're ever bored, the citations that plaintiff's law firm, which maybe they all do AI. Maybe it's literally all just posting AI, and that's all this firm does. Every underlying citation they use is so funny. Sometimes it's for protective orders that don't do what they say they're for. Sometimes they lose. So it's just ridiculously stupid. So like here, they're saying affirming blanket protective order is issued inter alia, which I think means among other things, right? That's what that means, right? Among other things. Identity of witnesses to avoid disclosure of highly personal and embarrassing information. But it sounds like the protective order that this court was granted had more to do with the CDC's purpose is the protection of the public health. Central to this purpose is the ability to conduct probing scientific and social research supported by a population willing to submit to in-depth questioning. Undisputed testimony in the record indicates the disclosure of the names and addresses of these research participants could seriously damage this voluntary reporting. Even without an express guarantee of confidentiality, there is still an expectation, not unjustified, that when highly personal and potentially embarrassing information is given for the sake of medical research, it will remain private. Second, P&G was provided with an enormous quantity of information regarding the center's research into toxic shock syndrome. Every single document requested was delivered. The sole deletion concerned names and addresses. It's not like I don't get it. Is Jane Doe just intending on going out with a bang? Any future legal career must be sustained or stained after. This person is not ever going to law school. I think initially they were gaslit or yaslit by a bunch of retards that all hate me, people like Jistical included, that I think have a lot of responsibility in what will be like the destruction of plaintiff's life basically after this. But now this is like her whole life mission is probably to try to destroy mine. Like it's basically the only thing she has going for her. And so this is like her whole thing. They weren't witnesses. They were lying about what this case says. Sure. Third-party witnesses. I guess kind of, because they weren't really witnesses. It was just medical data that, it's not even, I don't know if that would be even considered a witness. Isn't this going to leave her completely broke? My guess is the attorneys, at least one of them, I think, is a family friend, and I think that they're just doing it pro bono. So she's probably just stealing your money from the Gibson Go. In fact, contrary to Bonnell's contention, courts have recognized that such protection applies especially to third-party witnesses, given that these witnesses have not chosen to avail themselves of the public forum of the court. Do I want to read all these? I stopped reading a lot of their underlying because it's just boring now. Everything that they cite is just so fucking stupid. I wonder what this has to do with chosen to avail themselves of the public forum of the court. It's not cited here, or it's not in this. And many litigants would love pseudonymity. That's particularly obvious for defendants. Hey, that's me. Most of whom are being sued over alleged misconduct. Indeed, defendants can claim a stronger case for pseudonymity on the theory that such a defendant is not the one who has chosen to avail herself of the public forum of the court. Holy shit. Wait, hold on. I'm misunderstanding this. This has to be a different citation. This cannot possibly be. That can't possibly be real. Hold on. No shot is this real. I'm misreading this. Give me a second. Hold on. Because this underlying citation is saying that people like me would have a public interest in having a pseudonym, and they're citing this case. A defendant, that's me. Many litigants would love pseudonymity. That's particularly obvious for defendants, most of whom are being sued over alleged misconduct, and then they cite to that case. These guys cite to a case saying that witnesses have not chosen to avail themselves of the public forum of the court. But that's not true, though. The witnesses literally have chosen to avail themselves. They're not being compelled by any subpoena. They're not being compelled by anything. They're not being forced to come forward by some kind of order or arrest warrant or anything else. Before, a typical employment lawsuit, for instance, would rarely be reported in newspapers or Googling people's names will often find many of the cases which they participated, even if no reporter has ever written about these cases. Anonymity is thus a question of interest to privacy scholars and not just civil procedure scholars. Note there's a different issue from whether private parties publishing information for court records is restrictable. It isn't. Or whether a European-style right to be forgotten should be adopted. This article focuses only on what information should be... Wait, what is this underlying court case now? Also, wait, hold on. Did they... No, hold on. Chosen to avail themselves of the public forum of the court. Hold on. Chosen to avail themselves of the public forum of the court. Third-party witnesses. This has to do with the defendant? Hold on, I really want to see this. Is it the exact same... the court's previous order that Jane Doe may proceed under pseudonym. And Jane Doe is the defendant in this case. In an order on November 16, 2017, the court granted defendants administrative motion to allow Doe to proceed under pseudonym and to seal the filings containing Doe's true name. Because the court issued this order on the evening before the planned evidentiary hearing on plaintiff's second emergency motion for a preliminary injunction, the court did not have time to issue a detailed order. As a result, the court now provides its reasoning for granting the administrative motion. A district court has discretion in deciding whether to permit a party to proceed anonymously. The court must balance the party's need for anonymity with the prejudice to the opposing party and the public's interest in knowing the party's identity. In general, compelling reasons sufficient to outweigh the party's or the public's interest in disclosure and justify sealing court records exist when such court files might have become a vehicle for improper purposes, such as the use of records to gratify private spite, promote public scandal, circulate libelous statements, or release trade secrets. With regard to allegations of sexual assault or sexual harassment in particular, courts in the Ninth Circuit have found that allowing victims to proceed anonymously, victims would be plaintiffs, serves a strong public interest in protecting the identities of sexual assault victims so that other victims will not be deterred from reporting such crimes. See Doe v. Pensato. Okay. Quote, in keeping with the tradition of not revealing names of the victims of sexual assault, we use initials here to protect the privacy of the inmates. In EEOC versus ABM Industries, for example, a court permitted plaintiffs to intervene anonymously, in part because they were concerned that they would be embarrassed by the public disclosure of the nature of their allegations against defendants, which, if proven, will identify them as victims of sexual harassment and sexual crimes in the small community where they live and work. Defendants argued that Doe's need for anonymity outweighed any potential prejudice to plaintiff and the public's interest in knowing her identity. Defendants alleged that plaintiff brought this lawsuit for the purpose of embarrassing and intimidating Doe. At one, defendants argued that plaintiff included in the complaint private information about Doe's performance in his course, as well as the sensitive allegations that she privately made in a confidential university investigation. So like all of the random stupid shit that Pixie included in her complaint that was totally irrelevant, a lot of which they've admitted, by the way, is utter bullshit. I don't know if that's private or if that was part of the hearing, but in the hearing, they admitted that like half the people had deleted their accounts, that they had I don't know if I said this or not. One of the very specific lines of questioning, by the way, was, have you seen evidence relating to Abby MC, the mystery person? Have you seen evidence that Stephen Bunnell transmitted any video to her at all? Or is it just her saying it to a friend? And after some back and forth, she answered, no, I've never seen any evidence. And the question was, have you seen any evidence of him transmitting this video to anybody at all beyond the Rose person? And the answer was an unequivocal no, meaning that the Abby person lied, as I said they did. I know they did, because I went back and showed they perjured themselves in their declaration. But not only did she commit perjury, the law firm itself was at best reckless, because how are you having her fill out a declaration when you should have seen the evidence, right? If she's saying she has it, why wouldn't you check it first? It's because they're just trying to survive summary judgment. That's the goal. I don't even know why. Like, they want to go to trial, I guess. I have no idea. I don't know what the goal is, but defendants argued that plaintiff would suffer no prejudice as a result of allowing Doe to proceed anonymously because plaintiff already knows Doe's identity. Finally, defendants argued that the public's interest weighed in favor of allowing Doe, this is the defendant, to proceed anonymously to prevent other victims of sexual harassment and assault from being deterred from reporting such behavior. Defendants, right? This is defendants when they're the defendant, right? Okay. Plaintiff opposed defendant's administrative motion. Plaintiff argued that Doe had not identified what harm she would suffer if made to proceed in her true name. Plaintiff argued that sexual harassment victims, as opposed to sexual assault victims, are not typically allowed to proceed anonymously. For this proposition, plaintiff relied on a number of out-of-circuit cases where the victim seeking to proceed anonymously was the plaintiff. Plaintiff also claims that he has the right to attack her credibility in public rather than her hiding behind a cloak of secrecy. Finally, plaintiff claims that he has the right to defend himself publicly, where there is a greater incentive for truthful testimony. Doe, as the accuser, has to proceed publicly so so that other presently unknown witnesses may learn that it